will be for Michael Kelly, 580520247. Michael Kelly.
Good afternoon, Judge Grant. Sorry, I was muted for a quick second.
Okay, go ahead and put on your camera, please.
I believe there. How do I do this?
In the bottom left corner, there should be something that looks like a little video camera on the bottom. Just hover over.
I'm on top of mine.
Do you see where it has like video, participants, the chat? Should be a whole.
Think so. Yep, got it. Thank you. Sorry about the delay there.
All right, so it looks like you're here at the courthouse.
Yep.
All right, so sir, this case is for a ticket for operating a vehicle without proof of insurance. I have a violation date here of May 19th, 2025.
Thank you, Alyssa. This is
You've
her
asked
fault.
to contest this violation, which is a denial that it occurred.
I'm contesting on the validity of the entire traffic stop from initial point of before the traffic stop initiated. If I may explain on the, or at least expand further on that.
Well, if we're going through the contested hearing, basically what happens is I read the documentary evidence that has been provided to the courts. I have an officer citation that I would review, and I would then provide you with an opportunity to testify under oath, and you could make an argument if you like after that point. On an insurance violation, if you had insurance at the time but just didn't have the proof with you, the statute allows for a dismissal, and the court would impose a $25 fee for that. So if you were insured but just didn't have the card, a valid card showing that, that is one way to resolve this. But otherwise, if you want a contested hearing and to make a legal argument, we can do that as well. And it looks like I have been provided with some documents that you brought in today.
Correct.
Like there was some public record request, and is this a pay stub? Okay, this looks like a pay stub.
Uh-oh.
Did you mean to give me that? And looks like
that
credit card.
that one in particular was not supposed to end up in your possession, Judge. Sorry about that.
Okay. All right, got a few pages that maybe like some work history and minutes. I'll set that aside, and we'll bring this back out to you when we're done with this hearing. Have the incident report. And then this looks like an email string here. This is 5 pages long, so we can go through those. That's your materials.
It's all done online. Okay, thank you very much. Oh, but again, so I don't know the officer.
All right, so I have a citation in this case, and it is report number 2025-4230. The infraction number was 5A0520247. The issuing officer was Sam Gowan, Lake Forest Park officer. Her number is L323. It indicates here that it was issued to a Michael John Kelly. Lists the driver's license that has an expiration of 2/1/28. The address is noted. Date of birth 2/1/88. And the location was SR 104 at the 17500 block. Violation was 5/19/25 at 12:08. It would be an AM. So the vehicle was the Dodge Ram truck, the 2006 vehicle. So this citation was for the violation of RCW 4630-020. The narrative in this case, it says on 5/19/2025 at about 0700 hours, I was conducting uniform patrol in the 175th block of SR 104 in the city of Lake Forest Park, King County, Washington. I was driving a fully marked Lake Forest Park police car P13 and wearing my full Lake Forest Park police uniform when I observed a silver Dodge Ram Washington plate D34580E passing me, going over the posted 30-mile-per-hour speed limit. I initiated the traffic stop where the driver was positively identified by his Washington State driver's license as Michael J. Kelly, date of birth 2/1/88. I asked for his license, registration, and insurance. Kelly stated to me that he does not have insurance. I advised Kelly that I was not going to issue a citation for speeding or his expired registration, which had expired 4/11/25. However, I did issue a citation for driving without insurance. I explained to Kelly the citation and advised Kelly the instructions on how to take care of the ticket. That is the information that is provided on the citation. These are signed under penalty of perjury. Mr. Kelly, that's what the city has presented. I'm going to give you an opportunity to testify, so I'll have you raise your right hand. Do you swear or affirm that the testimony you're about to give will be true and accurate?
I do.
All right, sir, you are free to testify now.
So up to the point that Officer Goen initiated her stop, I was actually decreasing or accelerating speed from actually 35 down to 30, having seen the red light going eastbound on State Route, well, not State Route, sorry, coming down off of Ballinger Way, heading for Kenwood. That deceleration was when she passed me, and at about that point, she flipped around behind me. I stopped at the stoplight on the junction down here, State Route 104/Ballinger Way, at a red light where it was lit. And then when I pulled around the corner on the green light when it was given, she lit me up. She pulled me over, told me that she was pulling me over for speeding 42 in a 30-mile-an-hour zone. When she went back to her vehicle, when she asked me for the license, registration, and insurance, I gave her my license, stated that my insurance information could be found on her computer system, and that I did not have my card on me for my insurance information at that time. She went back to her vehicle and apparently tried to find my information, find record, all that kind of stuff that their systems have on their law enforcement vehicle computers.
I do not believe that they are able to look at people's insurance. I've never heard that. I've only heard the opposite. So that's something that you are responsible for, having a card that shows valid dates. I just don't think that that is something that police can do. So I'll just say that right now. I don't think that's possible. There's so many different insurance carriers, unless there was like state, maybe government ordered proof, like for a DUI, SR 22 on your driving abstract. I don't believe the police have any way of knowing that. So
having
I will,
watched,
unless it's part of your driving record.
so having watched the body cam footage, I was able to identify that she does have access to that kind of information. Having
Which is
seen
number one,
inside her vehicle
wrong.
during the traffic stop on the body cam footage, she does have access to the information. I do not have that body cam footage available, unfortunately, right now, because of the fact that it is on my other laptop, which is not set up for Zoom. And I unfortunately can't email it over because apparently Yahoo
Darn
has
the bad luck.
Data transfer limitation
Why would you
of
need
only
that on the
25
day of trial?
megabytes, and this body cam footage is rather lengthy from that particular traffic stop for both going and
What are you saving it for?
Can
I ask you that?
Officer Becker. I believe he was King County Sheriff's Department Transit Police, though.
Officer Becker is a Lake Forest Park police officer.
Okay. He had a different vehicle that had a different identification on it, and that's what I'm going off of, but that's fine. I can verify, at least through the body cam footage, that she does have access to that information as far as insurance and what agency, that kind of stuff. Her computer consequently and unfortunately froze in the middle of her trying to find other information, and it led to obviously the speeding warning instead of it being an actual ticket. And then it also led to no citation on the registration tabs. But she did issue the ticket, obviously, for the no insurance based on apparently me having said that I don't have the insurance card on me at that point in time, which I find to be, in consideration of Wren versus United States, to be an illegal traffic stop, because just me by myself telling her that I don't have my card on me doesn't mean she can't look it up on the computer system, which, like I said, through dash cam was proven. The other issue here is what I'm arguing on the validity of the overall traffic stop in general is she pulled me over, claimed that I was going 42 and a 30, and provided absolutely no confirmation or proof. And then on her body cam footage, she doesn't provide anything that verifies I was speeding either. Again, referring back to Wren versus United States, the validity is in question under poison fruit of the tree. Had this traffic stop not been initiated based on what I believe to be a invalid reading and no reading provided, therefore insufficiency of evidence, I believe honestly that no insurance claim should be suppressed.
I want to dumb her down the
that.
ticket. Like I want to fight that.
There is no apparent evidence that was provided either in the incident report nor in the communications between me and the department regarding a public records request, which is provided. It also states in the request that the department does not keep a record of the readings where no ticket is issued for speeding. And additionally, in this case, because a warning was given, there is no reading, there is no record, no nothing of what I was going speed-wise. So the speeding issue was the first claim that she made. And subsequently, because that has no proof at all for her to have committed initiated the traffic stop. The issue with the no insurance is what I would consider null and void under Wren versus United States.
All right, I'm going to deny your motions to dismiss. I don't believe they are on point. What I have before me is the officer's sworn statement. I don't have anything from the officer that she used a radar or LiDAR or any device to measure the speed that you're going. She doesn't assert that you were going a particular speed. She indicates that you passed her and you were going over the posted speed limit. Officers are able to make visuals of speed. A layperson can estimate speed so that she can use her expertise as a police officer and as a driver to know that whether or not you are exceeding the 30-mile-per-hour speed limit.
Why are you unnecessarily wasting the judicial time of this court?
You are not, whether or not you had insurance that you're saying, she said you told her that you didn't have insurance. The statute requires under RCW 4630.020 that you are required to have the insurance, and failure to provide proof of motor vehicle insurance is a traffic infraction and is subject to specific penalties. It says when asked to do so by law enforcement officer, failure to display proof of financial responsibility for motor vehicle operation as specified under RCW 4630.030 creates a presumption that the person does not have motor vehicle insurance. So it's your obligation to provide that. It's not the police officer's obligation to look to provide that information for you. So if you had insurance at the time, you could display it. If the law does allow me, as I said earlier, if you had insurance but just didn't have the proof to provide, it does afford the court the option of dismissing because you had insurance. That's the most important thing. They want to make everyone on the roadways have coverage. This isn't a situation of fruit of the poisonous tree, as you are asserting here. The officer made a traffic stop based upon her observations of your vehicle. She says you passed her. You haven't presented. You've said that you've seen other materials, but you have not presented them here today. I don't have any indication about a speed measuring device, whether or not one was even used.
That proof is in the email from
I think that they said they
PD
don't.
records, and I did not say that they don't. I said that they do provide this information in here. Let's see here. Under the incident report, going to be page 3 of 5. The radar or LiDAR equipment does not keep a historical record. And for this vehicle in particular,
Where are you
first-
reading on this? I'm on page 3.
Sorry, page 3, top of the page, under first paragraph, whether Officer Goins' patrol vehicle had radar equipment on the shift of the traffic stop, they state yes. They identify it, number DD028690, installed in patrol vehicle number P13, and officer was using during shift handheld LiDAR device number LA04.
I see that, but that doesn't say she used that device on you. It says that her vehicle did have that device in the car, but it doesn't say.
Which provides
it was-
insufficiency of evidence to state a reason for her to pull me over. There's nothing.
No,
given-
that one does not
Here.
lead to the other. One does not lead to the other. So that does not tell me that she used that device and had a reading And it says here it doesn't keep a record. If that had happened, I don't know that that happened, sir.
Which means the speeding aspect for her pulling me over in the first place was invalid.
No, it doesn't. Well, I don't,
That was her initial cause, probable cause for pulling me over in accordance with
Not
probable
based on
cause
a radar.
regulations.
no, I'm finding that she has indicated that you passed her on the roadway. She deemed you to be driving in excess of 30 miles per hour. She is able to make a traffic stop based upon that. I don't have any indication here that she used a speed measuring device, that she believed you were going 42 and a 30, which is what you're asserting. This document you provided to me does say that her vehicle is equipped with one, but it doesn't say that that's what she utilized in this traffic stop. So I don't have any information in which to make that finding. I find by a preponderance that it's more likely than not that the stop was made based upon her observations, which she detailed in the citation, that she issued warnings for the things that she noted the warnings for. You made an admission to her that you didn't have insurance, but in fact, you did not provide her with any proof of insurance. It may be that you had insurance. You didn't provide proof. That is what is required. You could have provided proof today to the court if you had coverage. You haven't done that. You've provided, I don't see anything persuasive in the materials that you submitted that shows that it was a improper stop of the vehicle. So I am finding it committed by a preponderance. The violation carries a penalty of, I believe it's
She's good.
$559 for not having proof of insurance.
This is just a much
But that will
nicer,
be committed.
much slower version of the Chisinator.
You are entitled to appeal this, must file one within 30 days.
Chisinator would have dropped a no
But as of
by this point.
now, this violation is committed, sir. Oh, I need to get you your papers from your workplace. All right. I'm gonna take a moment, take a recess.
Oh, sweet Jesus. Fruit of the poisonous tree means that there's some violation
State anything else wise.
of the
Okay.
Fourth Amendment. You
Judicial
can't use any
violation.
evidence that you got by so for instance, if you do an illegal
Was there
search and
something else
seizure
you wish to say?
and it leads
You
to
were
other
found
evidence
committed.
that
I don't
fruit
know that there's
poisonous
anything
tree.
else. You're entitled to appeal. Was there anything?
Since you're imposing that fine, without having asked me if I wanted to see anything beforehand, that's the reason why I had stated that it was another judicial misconduct, because
It's an infraction, sir. You are applying criminal rules. This is an infraction.
I still have freedom of speech as a last action to ask or state something in regards to my situation after you've imposed the fine.
And what did you want to say about the fine?
My ability to pay at this point in time should be considered. The fact-
Oh, sweet Jesus!
I don't have to ask
What?
about that, but it is imposed. If you'd like to make a record as to your ability to pay, you may do so, but that's at your request. You're entitled to make that request and you can go right ahead.
My ability to
there's
pay
something
is
you
restricted
say-
based on the fact that I am a temps agency worker. My criminal background has a very serious, sorry about the pronunciation, very serious background that restricts about 90% of types of jobs I can work. And as a temps agency worker as well, I have
Sucks
very
to be
little
a convict,
income.
huh?
And that's the reason why I did have my pay stubs with me today in prep for what I thought obviously this would happen. My amount of
I thought you did not intend for me to see those. That's what you said, but is that you want me to
I'm
consider?
sorry that I didn't clarify earlier more specifically. We were kind of obviously dealing with things both ends of our side
That's it
here.
in a nutshell, Scott.
I did, if this happened with regards to imposing the fine, intend to present you or provide you with the pay stubs because of the fact that my work history right now and my ability to work is extremely and rather outrageously restricted based on both my criminal background and the amount of work history that I have, which rather unfortunately is a lot less than the last guy that said he does DoorDash. And I'm willing to bet is a lot less than the rest of
Can I
your
go back?
caseload you're going to have to go through today. Being that I have recently been terminated from 2 different other temps agencies out of 4 that I've been working at over the course of the last 3 years, only having 2 that allow certain types of work for me to go out on, such as job site cleanup for construction locations, flagging, minor trade fields like that, and on a very sporadic basis. $559 is not going to get paid inside of a 30 to even 60-day window. And on top of that, providing insurance, I have been advised under other attorneys not currently representing me not to say anything about that. So at this point in time, I'm
About what?
asking
To not say something
about
about what?
saying anything regarding whether I've got insurance or not. So I'm not going to be
Well, if you
clarifying
had
anything on that.
insurance, if you had insurance, sir, that would be a wonderful thing for you to say. If you had insurance at the time of this violation, this infraction would be dismissed. So that would be a very smart thing to say. if you
One
had
way or
insurance.
the other, I've been advised against it. That's
Then-
all I'm going to
Well,
say
it's
right now.
been
for
found
that.
committed, so that's neither here nor there at this point. So the $559, you are working sporadically? Is that your,
Very sporadically, as in the last time I actually had work was almost 2 months ago. Almost. No, a month ago. 7/24 was my last work day. Then I've been going into the offices every single time that I can over at HireQuest of Everett and Seattle Trade Labor Corps downtown. And having my record the way I do right now, that makes things extremely difficult for me to be able to garner any gainful income, any money that can be put towards gas bills, transportation costs, like even getting around in general is difficult. I'm having to take buses. I'm having to rely on other people for driving me to and from work locations, paying out
Mr.
gas.
Kelly,
bills for
there are a
them.
lot of consequences based upon your criminal history. And so that is unfortunate, but that is the reality in which you're operating under. So what I can do here is I can put you on a time payment plan. I don't know that you would be able to do community service to cover any of the financial obligations, so that is usually an option. Sounds to me that you're keep stressing how limited it's going to be. I don't know that that is going to be viable for you. So if you would like to make time payments, we can put you on a payment plan that may be more workable. Are you getting government benefits?
The only thing I'm getting right now is SNAP, so food stamps.
Mhm.
They're basing their amount right now on the last 60 to 90 days of income, and I just was granted that SNAP benefit about 2 weeks ago, which prior to this incident, actually not prior to the incident, during that time frame and into June, I was making enough money, and so benefits to income ratio was considered. But after the last 2 months specifically, it's been extremely difficult to find work because those 2 agencies had conflict issues with me with them. I self-terminated from one, the other actually fired me. So I can, I believe, to a small extent, work a payment plan.
Self-terminated.
That's not to say that I'm going to not take the matter up for appeal.
You may certainly do that. No one is stopping you from doing that, but in the interim, that is an obligation that is owing. So
Yeah.
you should begin making payments on that, and hopefully your working status will change and reflect what you were making earlier in this year. I will send out the paperwork. I'm going to give you back your financials unless you want the court to keep a copy for our file.
You're welcome to keep those.
Okay, then we'll do that. We'll put this here in the packet and we'll send out a payment form with the $5.59 and you can sign to make time payments on that. All right. And you can just put the laptop computer on mute out there, if you will. Thank you.
Yep.
Okay, it's time for a new Law Talk with Mike feature. It's called Go Back and go back to the spot that you stepped on. Alyssa gave me the timestamp. Let's see how this works.
Lois, are you stopping the recording? I'm going to take a moment, take a recess.
And no allowance for me to be able to state anything else wise. Okay, another judicial violation.
Was there something else you wish to say? You were found committed. I don't know that there's anything else. You're entitled to appeal. Was there anything?
Since you're imposing that fine, without having asked me if I wanted to see anything beforehand, that's the reason why I had stated that it was another judicial misconduct, because
It's an infraction, sir. You are applying criminal rules. This is an infraction.
I still have freedom of speech as a last action to ask or state something in regards to my situation after you've imposed the fine.
And what did you want to say about the fine?
My ability to pay at this point in time should be considered.
I don't have to ask about that, but it is imposed. If you'd like to make a record as to your ability to pay, you may do so, but that's at your request. You're entitled to make that request and you can go right ahead.
Ah, yes, that was the height of his stupid. I do recall it. Like I just saw it 10 minutes ago. It was good. the judicial misconduct thing. No, it doesn't work. It does not work. I'm sorry. You are awarded 0 points. All right, I got more. Don't you worry. I don't know what's going on here. This is from Law Nerds Unite, Zach, and I think Matt UK.
I'm going to just call that case. This is the State of Michigan versus Jonathan Winter. There are a number of files. Let me put all of them on the record. First is file 25-43947-FY, set for a status review. Next is file 25-43928-FY, also set for a status review. We have file 25-43901 set for a status conference. That's a misdemeanor. We have file 25-43924-FY set for a status review on the felony. So we have 4 Winter cases. Mr. Winter, are you able to hear me now?
Can you hear me, Your Honor?
I can. Thank you very much. All right. Last time we were in court, you asked for another court-appointed attorney, and I indicated that I would grant that request and see if one would be scheduled. Since that time, I've learned that the court-appointed attorney's office has denied that request, and you're stuck with Mr. Brown, apparently. Mr. Brown, have you had any additional information?
I did, Your Honor. I did receive that denial. I have attempted to speak with Mr. Winter again. Basically, we are having the same situation. He will not really speak to me other than telling me what I need to do. I'm not really sure where to go from here. At the last court hearing, he wanted a psychological evaluation done. The court explained that to him. I've explained to him, I could request some sort of a forensic interview, but that's generally done for pleas of insanity, which I don't think he really understands what the all is entailed, because the communication really broke down there and he would not really listen to me explain the different plea options he has. Again, he is essentially trying to tell me how to run the case based upon things that he wants. And while it is, obviously, I am going to do my absolute best to represent my client, I have certain ethical and legal, I have certain ethical and legal obligations, and there are certain things that I cannot do or I won't do, because that could get him into trouble and me into trouble, Your Honor.
All right. Thank you, Mr. Brown. I appreciate that. Mr. Winter, I am going to give you an opportunity to say something in just a minute, but first I want to make sure that you have the appropriate information. I have received a written request from, I assume that this is you, Mr. Winter, and I'm trying to make sure I can read it. Says that you are the defendant in the above referenced case, and you request a new court-appointed attorney for the following reasons. Then you wrote in the box, it appears to say misrepresentation due to refusal to order tests I need done, and refusal to take statements or to call as witnesses to prove history of mental health issues getting worse, not acting as my lawyer, but as a prosecutor towards me in, and I can't read that final word. Then it says Larry Brown Jr. To be replaced. And then I've also received a document entitled with the case name on it from the MIDC contract administrator, Mr. Slough, which addresses your request for substitution of court-appointed counsel and the MIDC counsel administrator determination in which he denies your request. Have you received a copy of that document?
I have it in my hand right now, Your Honor.
I'm sorry, yes, you do?
Yes, I have it in my hands right now.
Okay, I just didn't understand what you said. So that's the status of that request. Is there anything that you want to add to that at this time?
Really, Your Honor, the conversation that I had with Mr. Brown on the phone yesterday, obviously he said did not go very well because it didn't. Because pretty much in the middle of it, he pretty much told me that he's not going to represent me properly because he just thinks I'm a criminal. I'm nothing but a criminal. That's not what a defense attorney is supposed to say to his client, Your Honor. I'm sorry.
Whether he said it or not really doesn't make a whole lot of difference. The question is, does he represent you well in
because
court?
that means he's discriminating against me and holding prejudice against me because of my past offenses. Yes, I'm dumb. I got a lot of.
Oh, sweet Jesus. Oh, my God. It means he's discriminating against you. No, it means he had a private attorney-client conversation where he was getting real with you to minimize the damage. You probably are a criminal. You probably shouldn't be announcing the contents of that conversation in open court to the judge. The attorney probably could have done you a hell of a lot of good because he's based in reality. And that's all the judge or anybody else is thinking from this. You have a good attorney who made the mistake of being honest with your dumbass in a private conversation. I'm better now.
Offenses, I was stupid, and I made a lot of mistakes. But that does not justify the kind of person that I am. It does not tell me the kind of person that I am or the kind of problems or issues I was having during these times.
All right. Thank you. I want to make sure that you've completed your statement there before I say anything else. Are you done, Mr. Winter?
Besides requesting that I get a responsibility test done or whatever, I need evaluations done, Your Honor. I'm sorry. Mr. Brown told me that it would take a while for that to happen. I've been sitting in here for a long time waiting for it, and I don't care how long I gotta wait for it. I don't. I gotta have these done, and I gotta be able to prove and have people, because the only people that I can have talk to and prove my past mental issues are my family and my family doctor.
Okay.
Your Honor,
And I get told all the time that my family's not good enough to provide this information, or my doctor.
All this bothers me so much. This is getting my attorney dander up here. I can't deal with it. I cannot tell you the number of times I've had uncomfortable conversations with my clients. I've told them stuff that they don't want to hear in the privacy of our office. Hey, this thing you keep saying to me, I don't believe you, and nobody else is either, and your whole claim is going to go down. You need to let that issue go, or we are going to lose. If you persist in that, you're going to need to find another attorney. I've had more clients crying in my office in private than you can shake a stick at. Believe me. And a lot of those people, after a little tissue and some time and a deep breath, we didn't do the stupid thing, we prevailed, and they got paid. Because I know what I'm doing, and they don't. That's why they hired me.
Mr. Winter, you have to wait. You're going to get time to say what you want to say, but you can't keep talking over. As soon as somebody else starts, you can't start again. So when you take a breath,
That's why I kept going.
are you done now?
For a minute, yeah.
All right, then Mr. Brown wants to say something, so let him have his say. Mr. Brown, go ahead.
Your Honor, again, we did go through this at the last court hearing. I did try to explain what the forensic center was, but I couldn't get very far. I was trying to explain that a mental health illness in and of itself does not negate guilt, but it is, the going to the forensic center is essentially trying to see if the person was legally insane or not. There are some other types of pleas or trials that we could have as well. I am just not getting anywhere. I don't think, well, I got to be careful. I don't want to get into privileged communication, but I don't think he is understanding. I cannot just request a psychological evaluation such as we might do in a child protective proceeding or something like that. I don't
All right,
think that's available.
thank you. Mr. Winter, I'm going to give you an opportunity to speak in a minute, but I want you to listen to what I say first before you begin to talk, all right? Mr. Brown is a very experienced defense attorney. He knows an awful lot about the criminal justice system because he's been doing it for a very long time. He practices in front of me on a regular basis, and I mean that multiple times every week. So I've had a chance to see what he does and how he does it. And in my mind, he's a very experienced and accomplished defense attorney for criminal law. If he's going to be able to help you, you're going to have to listen to what he says. I don't ask you to agree with everything that he says, but I need you to listen to as he explains what your options are. And in general, what he's said so far is my understanding of what the law is. You may be asking for something such as a psychological evaluation that the criminal law does not allow you to do or does not allow to be court-appointed for court-appointed counsel to do, and you may have to accept that. So I want you to discuss those things with him, but just because he disagrees with you does not mean that he's prejudiced against you. He may simply be telling you that the law does not allow for those things. Whether you agree with that or not, you have to accept. It's kind of like when you go to the doctor. You can get a second opinion if you want to pay for it on your own, but the second opinion doesn't necessarily cancel out the first one. They're each entitled to have their own opinion about how things work. Having said that, is there anything that you want to tell me now at this moment?
Not at risk of perjuring myself or hurting myself, but I'm going to say this anyway. Okay?
Well, I would advise you not to say something if you're going to perjure yourself or incriminate
It's
yourself.
not actually perjuring
Mr.
myself. It's nothing that I haven't said to you, Larry Brown, at all.
Well,
It's not-
those are privileged. Those are privileged communications,
Yeah,
what you say to
You
me.
you don't want to say things out loud on record that you've talked with your attorney about. Those are private things that you talk about. That's why we give you an attorney, and that's why we don't do it on the record, so that you can speak fully and freely without having to have things used against you later. So let me just put it this way. Mr. Brown is going to be your attorney. You're going to have to listen and talk to him about the things that he says he believes that the law allows and the law doesn't allow. If you disagree with, hang on, you got to wait till I'm done. If you disagree with Mr. Brown, then you have to put it in writing and make a motion that will be brought in front of me, and I will decide whether or not you get what you're asking for, okay? But if you've got to be able to talk to a lawyer and have some back and forth, and you've got to give some credence to what he's telling you the law says. It doesn't mean you have to agree with it, but it does mean that you have to consider it carefully. And then if only those things that you and he can't agree on, you can write a motion, and I will consider it after that, or the next judge will consider it after that. But you can't just say, I want to fire the attorney. That we've tried that and it didn't work, and it's probably not going to work in the future. So you got to work with Mr. Brown. Do your best to work with Mr. Brown. I'm going to give you some time to talk with Mr. Brown, but there may be things that you think should happen that can't. And you're going to have to live with those things because that's the way the world is. Not everybody gets everything that they want. Now, any last statements from you, Mr. Winter?
Guess not, Your Honor.
All right. We had an arraignment on the felony matters at the beginning of August. Mr. Brown, I assume that you need some additional time to speak with Mr. Winter and get prepared for whether or not he wants to have a preliminary examination?
I do, Your Honor. I have not even gotten to the point where I was able to discuss what a preliminary exam is and what it entails and the ramifications of waiving it or holding it.
All right. Would 2 weeks be sufficient?
Your Honor,
I'm sorry, Mr. Westbrook.
I actually do understand what a preliminary hearing is and what it entails. I do know. Because of past
I'm glad.
experiences and not fighting nothing. I do know what it's all about.
All right. So is Mr. Brown, having understood that, is 2 weeks going to be sufficient for you to prepare to whether or not you want to have a preliminary examination with Mr. Winter or not?
Yes, Your Honor.
All right, Mr. Winter, Mr. Brown is going to talk to you about having preliminary examinations or waiving preliminary examinations. I'm going to set another status review in 2 weeks. Or do you know now whether you wish to have the preliminary examinations, and I'll just set a preliminary examination in 2 weeks? Which would you prefer?
Are you asking me or my attorney, Your Honor?
I'm asking you at the moment. Do you want to have a preliminary examination in a couple of weeks? Or do you want to have 2 weeks to talk to your attorney about whether you should or not?
I need time to talk to him about a lot of things, Your Honor.
All right, then I'll give you that 2 week period of time. We'll come back in 2 weeks for another status review. But at that hearing, I am going to ask that we decide what to do about the preliminary examinations. All right. So have your discussions with Mr. Brown, make a decision about whether you want to have the cases, and I'll hear you back in 2 weeks. All right. Thank you, Mr. Winter. That's all for today.
I believe we need to address the 21-day rule.
I think that has been addressed before.
We already did on the 14th. He waived. Looks like I got that in my notes. All
Okay, I must have missed it in my,
All right.
my end then.
right, we're done then. Thank you, Mr. Winter.
Okay, sorry. That triggered me for a second there. I got a little irritated.
Good afternoon.
Warning, I hear this is
Good afternoon.
kind of nerdy, and you
Is
might
everyone ready?
learn
Is everyone
something.
here?
I don't know.
Okay, the court calls 2025 DCV 2373, Kent Hubbard versus Southeastern Freight Lines, Inc. and Samuel Contreras. Announcements, please.
Good afternoon, Your Honor. Jesus de Luna here for the plaintiff.
Good afternoon.
Kennedy Gerard here on behalf of defendants and Mary Henderson as well.
Thank you. And we're here on defendants' plea to the jurisdiction.
That would be correct, Your Honor.
Okay, you may proceed.
Your Honor, this plea to the jurisdiction was filed on behalf of our clients because a motor vehicle accident occurred in June of 2023, on June 2nd of 2023. However, when the petition was filed, it says that the plaintiff, Mr. Hubbard, was seeking future damages. It said that he would suffer from ailments in the future. However, Mr. Hubbard passed away 65 days before that petition was actually filed. Because he was deceased, but the petition was filed as if he was alive, there's no standing for the petition to be heard today. Standing is an essential element of subject matter jurisdiction. When the Texas Supreme Court has said time and time again, if there's no subject matter jurisdiction, then the court cannot hear the claim. Opposing counsel filed a response a couple of hours ago, and I believe that he knows that the petition was filed as if his client was alive, and
I
now
know the other
that
one.
there's this huge jurisdictional defect.
But this one's a cutie. There's no
But
two ways
if
about
you're
it.
looking at the foundation here, it's a negligence claim filed on behalf of somebody who did not have standing to do so. Therefore, there's no subject matter jurisdiction, then the case should be dismissed. Based on the response that we received, though, it seems as if there is a dismissal, because there should be one, it should be done without prejudice. But doing this would just be a workaround the fact that the statute of limitations has ran for this claim, being that the motor vehicle accident, which allegedly resulted in injuries, was in June of 2023. We do sympathize with Mr. Hubbard's family, being that they're grieving, but this sympathy shouldn't be used as a blanket to cover up the fact that a frivolous lawsuit was filed. Opposing counsel from our purview didn't know that his client had passed away until our office notified him that Mr. Hubbard had passed away. And now the statute of limitations has ran on the claim. In the response, they throw around hypotheticals like wrongful death suits and survival actions, but this isn't a wrongful death suit. Mr. Hubbard did not pass away based on injuries as a result of the June 2023 accident. Mr. Hubbard passed away in an unrelated motor vehicle accident in March of 2025, and then a petition was filed on his behalf in May of 2025. Since this is so, since there is no standing, then there's no subject matter jurisdiction, and this case should be dismissed with prejudice because the statute of limitations has ran. Thank you.
Run. It's minor. It's close.
You're on mute, Your Honor.
It's not the worst, but figure it out.
Sorry, I'm under the weather and was coughing a little bit. Thank you very much for pointing that out.
No problem.
John, you cited the Arms versus Thompson case. Did you find any authority that's binding on this court?
Not necessarily, Your Honor, but that case has not been disturbed up until this point. And the front end of that case is kind of twofold. The first half is that they said that there was no standing because the petition was brought by somebody who passed away before the petition was filed. The back end of that is the survival issue, which is where they tried to substitute in the estate, but the amended pleading wouldn't relate back, being that the initial pleading was null and void. At this point, I don't know if that is what Mr. DeLuna is trying to do or just trying to preserve some type of claim. But to answer your question, while it's not binding on this court, that Court of Appeals opinion out of Eastland hasn't been disturbed.
And did you find any contrary authority to your position?
Your Honor, there was one case that's seemingly contrary, and it's the Pena case that I cite in my petition. But that case has facts that are very distinguishable from this case. In the Pena case, the only defect there, was the caption. The caption said that the petition was filed individually, even though the plaintiff has passed away. But if you look at the substance of that petition, which is what the court said, the substance actually said that the petition was being brought on behalf of the plaintiff by the administrator of his estate, and it did not seek any future damages because they knew that their client had passed away. There literally just was a mishap in the case caption. That's not the case here. The case is captioned as if Mr. Hubbard brought the case himself, and they seek future damages as if he's alive.
And aside from the Pena case, I take it you didn't find a case similar to the facts of this case where the petition was filed on behalf of by the deceased purportedly, and a court later allowed amendment, substitution after the administration process?
No, Your Honor, I did not.
Okay. All right, Mr. DeLuna, and I understand, I heard from Ms. Short that you filed a response. I have not seen it yet. I don't know what time you filed it, so I don't have that benefit.
Yes, Your Honor. If may I speak? Yes. Yeah.
When did you file your response?
It was like 4 hours ago, Your Honor. And basically, we don't have we know that we don't have standing. We figured that out after the fact, right? We were trying to get to contact Mr. Hubbard, and we just couldn't. So statute of limitations was on top of us. That's why we filed. We didn't know that he had died until, of course, defense let us know. So our stance is we don't have, I mean, we know we don't have standing. We don't have an issue with the dismissal. The only thing is that, and we don't represent the family or the wife, right? Which is, I don't know if he has children or not, but I know he has a wife. We made her aware of it a few days ago because we couldn't find her either. She wasn't aware of anything yet, right? But we made her aware. So our only thing here today, and to respectfully ask the court that again, we don't have an issue with dismissing the file, but it's one that we want to make sure it's done without prejudice. Just because there's independent persons here or been heirs, right, that might be able to bring a survivable claim in the future. Again, we don't represent them, right, but we're here to basically just to see if we can respectfully ask the court that if they dismiss, which I think that if that happens, right, it's done without prejudice, Your Honor.
Okay, so my
Completely reasonable. I don't know why we sat around this long. Of course, the defense is going to ask for dismissal with prejudice so that it can't be rebrought. They're going to say no, and there are people that we don't even represent that may have a claim, and we don't want to prejudice all this stuff. That is probably not going to happen. I don't know what the judge does, but the judge should just say, fine, you can dismiss this without prejudice, and then what'll happen is nobody will make a claim because it's too difficult under these circumstances. It's the right thing to do here. I don't know what she does.
understanding you clearly that you're not really objecting to a dismissal as long as it is without prejudice.
Correct, Your Honor.
Okay, anything else, Mr. R?
Yes, again, opposing counsel is throwing around the hypothetical survival issue. And again, we sympathize with the fact that Mr. Hubbard passed away, but we asked the court that it be considered that we did a simple Google search and found out that Mr. Hubbard passed away before the petition was filed. The same thing that opposing counsel could have done before he filed his petition if he was trying to get in touch with his client. And at the end of the response, it talks about tolling for survival actions. But when a petition is filed, it's my understanding that the tolling stops. It's from our purview, from our purview, it's not our fault that the petition was filed not by the right person, but that's the case here. And now the statute of limitations has run. So we believe that there should not be any subsequent claim that is able to be brought based on the accident that happened on June 2nd of 2023.
We're not ruling on the statute of limitations right here. He's agreed to this dismissal. There are claims outside of him. He's just trying to not get sued. He hasn't done anything wrong, by the way. But it's just, I don't know. This is minor, but I think that defense is being a little upset. None of this matters. It's 10% of the teapot. These claims aren't going anywhere anyway you slice it. But he just doesn't want to have an issue. He can say, technically, someone else can bring a claim if they want to, but I'm not doing it.
Okay, under the circumstances, the court is going to grant the plea to the jurisdiction and dismiss the claims without prejudice.
There we
Mr.
go.
Do you have a proposed
Boom.
order?
Yes, ma'am. I believe we emailed that order to Ms. Dunlap.
Okay. Did you take a look at it, Mr. DeLuna?
I didn't. I haven't seen the order. But if they send it to me, I mean, I'll go ahead and sign it myself.
Okay, then if you'll just please let the court know whether you approve as to form or not.
Yes, Your Honor.
Did you say, Your Honor, without prejudice?
I did.
I'm sorry. Okay.
Anything else?
That's in our, on
No,
my.
Your Honor.
Okay, thank you all very much. We're adjourned.
Thank you.
Thank you, Your Honor. Are we excused?
Thank you, Your Honor.
Yes, everyone's free to go. Have a good afternoon.
Thank you.
Your Honor, I am not a human being. I am the legal representation of my given name.
That was fun stuff. Wait, here's what I'm trying to do.
Your Honor, as you can see,
I'm killing a couple minutes to take you to Biggin's stream. That's basically all that's going on here.
I do not consent. I do not consent. Your Honor, I am not the person in the video. The evidence is clearly faulty. It was tampered with. The person who you think is me has a different haircut. This is my birth certificate. The person is not me, as you can see. I do not.
Was it fun watching me set up that redirect? I have to go to another tab so I can't see. I didn't realize I put my goofy mug on screen for that.
The case law of America says that if the person who represents me is the people,
What are you gonna
who are
do?
not the papers. I am the boat. I am the boat. I am the boat. I do